Welcome to TrialView Network. Today, we're stepping inside the courtroom of Judge Raquel West, where every gavel strike carries real consequences. From stolen property to probation violations, today's docket is packed with tension, redemption, and tough justice. Watch closely because in this courtroom, mercy and the law walk a razor's edge. You'll see guilty pleas, life-changing rulings, and one defendant who might just talk their way into deeper trouble. So, what does accountability really look like when the stakes are freedom versus time? Let's dive into the drama.
We've emailed the attachment to you.
Okay, thank you. Good morning. Are you Michaela Marcantel? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Let me get to it. Ms. Marcantel, in cause number 25 DCCR 0528, you're charged with the state jail felony offense of theft of property from May 28th of 2022, continuing through June 4th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
This is a crucial moment, Michaela Markle. Is pleading guilty to a theft charge involving over $4,000 in property. What you're seeing is called a deferred adjudication, a legal middle ground that lets her avoid a conviction if she completes 5 years of probation and repays every cent of restitution. Think of it as a legal tightrope. One slip, and that deferred sentence flips into jail time. What's striking here is Judge West's tone firm but encouraging. She's not just sentencing. She's giving Markle a roadmap to redemption. Would you take that deal or risk trial?
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be $4,492.45 to be paid back in restitution, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders Number 1.
No objection.
It's admitted. Is there any evidence that Ms. Marcantel is not competent?
No, Your Honor.
And any reason not to waive?
She's never been arrested before, Your Honor. I don't
We've
have
got the
objection
amount.
to waiving.
All right, Ms. Marcantel, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. I'm also ordering you pay back the restitution in the amount of $4,492.45. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you are not a convicted felon. You don't have the conviction on your record. And if you successfully complete the probation, at the end, the case actually gets dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? That's a lot of money to pay back also. 5 years seems like a long time to pay it back, but it'll sneak up on you. And so it is very important to me that you start paying back that money immediately. Even if you pay a little bit a month, it'll add up. What can happen is you can do everything else you're supposed to on your probation. And if we get to the end of the probation period and you have not paid that restitution back, and I make a finding that you could have, you could still get revoked to go to prison after you've done all that probation. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over all of your paperwork. Good luck to you, ma'am. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
And Mr. Beard was previously in court, and you entered a plea of guilty to collision involving serious bodily injury. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
No, Your Honor.
There was a notation that restitution was to be determined, but I didn't see that there was any. Ms. Malfino, does the state have any notation or request, or did I miss it?
Now, the courtroom shifts to Colonel Beard, who's facing the aftermath of a collision causing serious injury. Notice how the judge initially says 10 years, but corrects herself. It's actually 20 years if he violates probation. That correction isn't small talk, it's a wake-up call. The stakes just doubled. This case underscores how probation isn't a get-out-of-jail-free card. It's a test of responsibility. A single violation missed payment, skipped appointment can turn probation into a full prison term. Let's be honest. Would you be able to stay clean and compliant for an entire decade?
I did send Mr. Davis the complainant a restitution request form. I have not ever heard back on that.
Okay.
So at this time, I don't feel like I have something to stand on the order.
Okay. All right, then, Mr. Beard, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. And if you do that, this is an excellent opportunity because you don't have the felony conviction on your record. And at the end of the probation period, if you're successful, the case is actually dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to prison for up to, is it 10? I'm sorry.
Just
20.
so the record is clear, it's 20.
20 years.
Two counts, one and two.
Okay, so you could go to prison for up to 20 years if you violate your probation. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you when she's ready to go over all of your paperwork. All right, good luck to you, sir.
Thank you, Judge.
Thank you, Mr. Rojas. All right, sir, you Kelton Hebert? Yes, ma'am. And this is 24 DCCR 1498. What is the announcement?
Judge, if we could have 2 weeks, Mr. Hebert was not able to come to my office since our last court date. There's a particular video he needs to watch. He's been working too much, but we'll make those arrangements if we can just have 2 weeks.
Okay, so this will be the final reset. You need to figure it out. I appreciate that you're working, but find a time to go visit with Mr. Gallimore before that next court date.
Here's a quiet but revealing exchange. Kelton Hirt gets his case reset because of a video he needs to watch. That might sound procedural, but it's actually huge. Court-ordered programs or videos often cover victim impact, accountability, or substance awareness. When Judge West warns that this is the final reset, she's signaling that leniency has limits. This moment is less about the delay and more about the system's patience wearing thin. Small administrative slip-ups can cost defendants dearly. Ever wonder how many people lose second chances because of something as simple as not watching the video?
It'll likely be 3 just because we're down, but
I looked at my calendar. Both of those are fine.
okay, all right. Stay in touch with Mr. Gallimore. We'll see you at the next court date. And then you have Duma. This is Mr. Hoffpowers. Good morning, sir. You're Duma Turner?
Yes, ma'am.
And in 24 DCCR 1998, Mr. Turner, you're charged with criminal mischief. And what is the announcement?
Judge, if we could just have a normal reset on this one, not had an opportunity to review all the discovery yet.
Looks like you were just got on in August. Any issues that you see?
No, Judge, it looks like there should be an offer in there and the restitution amount has been determined.
All right, so Mr. Turner, I'm going to just do a normal reset, about 30 days or so. Make sure you visit with Mr. Gallimore before that next court date. We'll see if we can get an announcement.
Sounds good.
All right, you're free to go. Thank you.
Judge. That's all I have.
Thank you, sir. Good morning. Are you Thomas Fisher?
Yes, ma'am.
And Mr. Fisher was previously in court and entered pleas of guilty in cause number 23 DCCR 1046 to aggravated assault with a deadly weapon and 23 DCCR 1047 criminal mischief, a state jail felony. I've received that pre-sentence report. Has everyone had an opportunity to review that?
Yes, Your Honor, we have.
Are there any additions or corrections?
No, not by the state.
All right, sir, I'm going to find in each of those cases that you entered your pleas of guilty freely and voluntarily. find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements in each case. In cause number 23, DCCR 1046, defer all proceedings for a period of 5 years, place you on probation. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And then in cause number 23, DCCR 1047, also defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine in that case as well, and to follow all of the rules and conditions of probation. This is an excellent opportunity because you have no felony conviction on your record. And so if you successfully complete the probations, then you will never have felony convictions, and at the end of the probation period, the case will be dismissed.
Now, Thomas Fisher's case ramps up the stakes to felony charges, including aggravated assault with a deadly weapon. But instead of prison, he's given dual deferred probations. That's rare mercy. What stands out here is the added condition: mandatory mental health and drug treatment. Judges don't add that lightly. It means Fisher's crimes likely stem from deeper issues: anger, substance abuse, instability, and the no-contact order. It's absolute. If he even messages the victim, that's an instant probation violation. This isn't just punishment, it's structured rehabilitation. Do you think courts should offer second chances for violent offenses?
One of the conditions of your probation is going to be that you participate in any and all mental health services as well as drug treatment. Whatever they say is necessary, then you're going to be ordered to participate in those, whether you think you need it or not. It's now part of your probation. And so all of that is meant to help you to stay on track and do what you need to do so that you can be successful. Also, you're specifically ordered you cannot have any contact with the victim, who is Michaela Stacy. That's also obviously contact in person, but that's communication in any way. You can't send messages, you can't send anything electronically through social media or anything like that. If you do, or you're around her at all, then obviously that's a violation of your probation. You're going to be right back in here. If you violate your probation in these cases and you are brought back into court, you could be found guilty in each of your cases. And in the first case, you could go to prison for up to 20 years. And in the second, I believe it's a state jail felony, you go to prison for up to 2 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. And then I will sign a dismissal in cause number 23 DCCR 1751 as part of this plea agreement. You need to have a seat here in the courtroom. Probation will call you up to her desk as soon as she's ready to go over your paperwork. Good luck to you, sir. Thank you, Mr. Macon.
If you're enjoying these real courtroom stories, don't forget to subscribe and hit the bell. We bring you justice in action, traumatic moments, and lessons everyone can learn, all from real cases.
Good morning, sir. You're Roland Guillory. And this is 24 DCCR 1568. Mr. Guillory was previously in court, entered a plea of guilty to the lesser included offense of a Class A misdemeanor, abandoning or attempt to abandon or endanger a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has to.
Any additions or corrections?
Just that I've reviewed it with Mr. Guillory. He would like the court to move forward with the plea agreement, and we understand the recommendations of for parents and classes, and until that is completed, for him to have supervised visits with the child, and also with MHMR.
Yes.
He's tried several times. Their system has been down for quite some time, but he said they were able to get him scheduled in.
Okay, good.
November 11th.
Okay.
Yes, ma'am.
All right.
No additions or corrections, Judge. I do have some concerns, particularly on page 1 under the defendant's version, where he says he doesn't feel like he committed a crime.
Watch this carefully. Roland Guillory admits guilt, but claims he doesn't feel like he committed a crime. That contradiction says everything. His charged child endangerment was reduced to a misdemeanor, but his mindset raises red flags. The court's solution: parenting classes, mental health intervention, and supervised contact only. Judge West is striking a balance: accountability without annihilation. It's a textbook example of restorative justice. The goal isn't just punishment, it's transformation. What do you think? Should denial like this affect sentencing, or should judges focus solely on rehabilitation potential?
I think that's an issue as well. I think with regard to that, probably some of the other issues that hopefully we'll address on the probation, and the fact that it was reduced to a misdemeanor probably covers that, but I did have the same concern. I think I'm going to go ahead and go forward. Are you okay with that, Mr. Coleman? Okay. Mr. Guillory, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes participating in the through Spindletop and whatever the recommendations are through that caseload on probation, completing the parenting class, doing everything you're supposed to, and then not having there's no unsupervised contact with any child until further order of the court. So if you go through all those classes and you're well on your way and you're following all the recommendations and following through with Spindletop, there may be a time where probation sends me back something that says, hey, he's doing great, we're ready to do unsupervised, but you're going to have to do everything you're supposed to. If you do everything you're supposed to on this probation, then this is an excellent opportunity because you don't have the conviction on your record. And if you complete the probation, then at the end, the case will actually be dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Getting care of this one outside of, down the hall.
Good morning, you're Seneca McDaniels, and this is 24 DCCR 1915. Mr. McDaniels is charged with unlawful possession of a firearm by a felon. Go ahead, I'm sorry.
Your Honor, we have an agreement in which this will be taken care of down the hall as well.
Okay.
So we can get a couple of weeks.
And he's already paid the fine, Judge. I will draw up a forfeiture document. He will sign it in Ms. Holmes' office, and we should take care of it before the next time.
All right, so I'll just do a normal reset. Obviously, if it gets taken care of before that court date, then you can just let him know. Otherwise, make sure you're here on that court date if nothing has been done before then, okay? All right, you're free to go.
Thank you, Judge. It'll be done this week.
Thank you. You've got a Zully Valicia.
And that concludes today's intense courtroom session. From Michaela Markle's financial redemption arc to Thomas Fisher's dual probation and Roland Guillory's denial, Judge Raquel West reminded everyone that justice isn't just about punishment, it's about precision, fairness, and second chances. Her rulings show that probation can be a gift or a ticking time bomb, depending on how you handle it. What did you think of today's cases? Who handled their situation best and who's headed for trouble? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe to Trial View Network for more real courtroom breakdowns where justice meets reality, one case at a time.